So it's an interesting time of the year. Many of you are starting the process of working through non-discrimination testing, starting to gather your information for your plan audit. And of course, what happens as a result of that is that you get a lot of questions about how your plan was administered within the last year. And you start thinking about whether there are tools available to be able to correct any sort of mistakes that you see. So we're going to talk a little bit about that today and just really put you in a position where you can potentially, hopefully, feel more comfortable with the number of corrective tools available to you. And here's really the starting point. The IRS lays out its correction program in this large revenue procedure that the current version is about 140 pages. And it's not easy to navigate. There's a lot in there. And I think that the IRS has demonstrated a little bit of self-awareness regarding the challenges in figuring out how to work through all of those corrective provisions. And so it recognizes that we need better tools and better access to information helping us to understand how do we navigate corrections when we find plan errors. And so within the IRS's big program, we refer to it as EPCRS, or some will call it EPCRS. But within that big program, and that's that 140-page document that I just referenced, there are three key areas for making corrections. There's the voluntary correction program, or VCP. There's the self-correction program, or SCP. And then the audit cap, or audit closing agreement program. We don't want to be in that one on the far right, okay? That's when we get in a position where the IRS is looking into the plan and is working with us to fix things. By the way, the IRS is easier to deal with there than the Department of Labor is, but that's really not where we want to be. All the way on the left, the voluntary correction program is where we've got good options to fix something, but we have to file a written application with the IRS and pay the user fee that goes along with that. So again, we can use that. That's not exactly where we want to be. If we find plan errors, we want to be in that middle category. We want to be in SCP. And fortunately, over the last couple of years, SCP has really grown. The IRS has recognized that it's fairly short-staffed and it really wants employers to self-govern and self-inspect plans when you can. And so the IRS has worked hard to make it easier to do things like retroactively amend a plan so that we have paper that matches the practice that we've deployed in the past. Well, fortunately, Secure 2.0 served to expand the self-correction program as well. So I want to talk a little bit about that today and help everybody to understand what Secure 2.0 does for your self-correction options. So under prior law, under Rev Proc 2021-30, remember I said we want to be in SCP if we can be. The time that you have to make a correction under SCP depends on whether a failure is deemed to be significant or insignificant. I'll come back to that in just a second. But if it's significant, it has to be corrected by the last day of the third plan year following the plan year for which the failure occurred. So it gives us kind of a 3+ year period or so to fix those errors. It used to be 2, and the IRS has extended that to 3. But that distinction between significant and insignificant, it's murky at best. Certainly a subjective or a qualitative decision. The Rev Proc gives us a number of factors that we can apply to help us arrive at a conclusion that something is insignificant, which gives us then an indefinite period of time to correct, or significant, which gives us a shorter period of time. Well, Congress worked on this a little bit, and within Secure 0.0, it just gets rid of that significant and insignificant distinction. So instead, moving forward, we can use SCP for any eligible inadvertent failure, as long as it's corrected within a reasonable period of time after we find the failure. So notice there that our deadline for making a correction, it says we've got to be reasonable after we find it, as opposed to tied back to when the failure originally occurred. This is going to be really great, I think, as you get into a position where you're looking for somebody to tell you, can we use SCP for this or not? And a lot of lawyers or consultants are hesitant to say to you very clearly, yes, this absolutely or categorically is an insignificant failure. This will be a little bit easier moving forward. So here are a few things though to keep in mind. First of all, the IRS is going to give us more interpretive guidance around this, so we'll be on the lookout for that. That term eligible inadvertent failure, that's a defined term. And so if you do get into wanting to correct something that's been a failure for some period of time, we do need to dive into Secure 2.0 and talk about what it means to be an eligible inadvertent failure. And then also, and this is welcome news for a lot of people, the expansion of SCP, it doesn't just do what I described above. It doesn't merely get rid of that significant, insignificant distinction. It doesn't merely extend the period of time that we can make some corrections, but also it makes it clear that in the plan loan context, we've got some relief from having to report loans on a 1099-R. And secondly, Congress directed the Department of Labor to say, if we follow these procedures for correcting under the IRS and Secure 2.0 guidance, the Department of Labor has to treat us as if we also met the voluntary correction program that the Department of Labor makes available. So a couple of welcome comments there that helps us to understand just how much the availability or the access to this will have expanded. So that's really the first half of what we wanted to talk about. You'll see some articles and headlines about expansion of SCP, and that's what it really means. We're going to be in a position where we can make a lot more corrections to plans without having to file a report with the IRS, without having to ask for the IRS's permission to bless our proposed correction, and without having to pay the corresponding user fee. Okay, so let's put that aside for just a moment and revisit this idea that the IRS has demonstrated self-awareness and given us some additional tools to use when we're trying to fix things within that SCP channel, within that self-correction plan channel. We've got a couple up here on the screen in front of you. On the left, we can see the IRS has given us this nice 401k plan checklist that allows us to very quickly run through and perform a little bit of an administrative or an operational look at whether the plan has been run in the right way. Now, these aren't fiduciary issues. Let's keep that in mind. We're not talking about how plan expenses are paid. We're not talking about the investment options or whether disclosures were given to participants. We're talking about how your plan is run and how it's operated. So we got this checklist on the left. But then the part I really love is this notion that there's a 401k plan fix-it guide. And I just have always thought, you know, the IRS is such a formal body. The Department of Treasury is such a formal body. The idea that it would come up with something so practical and casual as a 401k plan fix-it guide is pretty welcome news. It's the IRS really reaching out to the public and saying, hey, we really want to make this possible for you. And you can see that there's a chart here, and I've pulled out an excerpt showing the first 3 mistakes that the IRS dives into. It identifies the mistake, tells us how to find it, tells us how to fix it, tells us how to avoid it. And if we were to click on that hyperlink, any of those hyperlinks over on the far left category, it would take us to a dedicated page corresponding to that specific error. So if you've got a problem with number 3 where you haven't used the plan definition of compensation correctly, we just click on that, it takes us out, and there's a lot of instruction on how we would fix that. So you might be asking, okay, how many types of errors or mistakes does the IRS address in this regard? And there are 12 of those. So if you're dealing with plan mistakes that fit into any of these 12 categories, the IRS has gone to great lengths to make it easier for us to make corrections. And you know, you saw the first 3 on the prior page, and then we get into the failure to make a matching contribution to everybody. If we've got an ADP or an ACP testing failure. Number 6, this is the big one, and we're going to spend a little bit more time on this today, where we messed up on deferrals in some way. What happens when we allow deferrals in excess of the 402G limit? That's that limit on what somebody can put into the plan in any given year. What happens when we don't timely deposit deferrals, or we don't run loans the right way, or we make an improper hardship distribution? What about when we fail to make top-heavy contributions or fail to timely file the Form 5500? We can address all of those situations through this fix-it guide, and it's an incredibly helpful way to fix those. Now, I mentioned I wanted to spend a little bit of time, and probably the rest of our time today, on category 6. This is the most common issue that many of you will encounter as you start working through your plan audit, whether you're working out with a plan auditor or if your plan's not subject to the audit requirement, but you're looking back and trying to reconcile your numbers for last year. This guidance is incredibly important for you to ensure that your plan is being run correctly looking backwards, and then put you in a position to run it correctly moving forward. So here's the idea. We've got this mistake where, for whatever reason, employees, they weren't given the opportunity to make an elected deferral, or perhaps we just didn't honor whatever election they made. And that comes up in two big categories of situations. Number one, we've got an automatic enrollment plan, and we did something wrong with regard to automatic enrollment. Number two is when somebody made an affirmative election and we failed to honor it on a timely basis. So let's talk about those common contexts. In fact, we're going to flip the order of those and start here with a non-automatic enrollment plan deferral failure. So we're thinking about any of you who have a plan where you don't have automatic enrollment. And so you find out that there was a mistake in 2022 where you've got an individual who made an election to have a certain amount withheld from his or her paycheck, and we realize that we failed to do it on time or that we failed to withhold the right amount. So what is the corrective methodology for that? Well, number one, if you've got a matching contribution in your plan, we always have to make up the match that would have corresponded to that deferral. That always has to happen. We've got to make the match. We've got to include the earnings. But the next step then is, what do we do to make the participant whole for what he or she missed out on by us not putting that deferral into the plan? And here's where the law gives us these three levels of potential fixes. And in essence, the law says we have to make up for that missed deferral opportunity by making what's called a qualified non-elective contribution, or a QNEC. But then the next question is, how big must the QNEC be? Well, fortunately, the IRS in recent years has given us one avenue through which there would be no QNEC required. And that would be where, in essence, we figure out that this is an issue and we get the deferrals corrected and moving forward on a prospective basis by the last day of the 3-month period beginning after the failure first occurred. Now, if the participant brings it to your attention, as you can see in number 2 right here, you have to fix it a little bit more quickly. You've got to fix it by the end of the next month. But if the participant doesn't bring it to your attention and you figure it out, you've got roughly 3 months to get those going correctly. And then we have to provide a notice to the participant that meets certain requirements. If we do that, we avoid the QNEC entirely. You've got to make any sort of missed match, and we can go on moving forward without any additional correction. What happens though, if you find it a little bit after that 3-month period, or you don't get it timely corrected after the participant tells you, but you do get it corrected within roughly the next 3 years? Well, here's where we get a 25% QNEC. So if a participant elected 4%, and we failed to put that into place, and we find it more than 3 months down the road, but less than 3 years, in that situation, we would put in 25% of that missed deferral opportunity. What's 25% of 4%? It would be a 1% contribution plus earnings. We provide a notice and we move on. What happens if we can't rely on either of those? Well, in that situation, we're stuck. We've got to make a 50% QNEC. So in my example, rather than putting in 1%, which is 25% of 4, we put in 2%, which is 50% of 4 plus earnings. Secure 2.0 did not change any of these 3 levels. So keep that in mind, that Secure didn't impact these, but Secure does have some information relating to plans that have automatic enrollment. And within RevProc 2021-30, we got a safe harbor that says if you're an automatic enrollment plan and you fail to implement the automatic enrollment amount, or a participant elects out and we didn't put that into place, we don't have to make that QNEC, that missed deferral opportunity contribution, as long as we comply with these 4 distinct requirements. Number 1, the failure can't extend beyond the end of the 9.5-month period following the end of the plan year of the failure. This is a lot of time to get it corrected. Number 2, we got to get those deferrals going. In essence, you got to get them going by that deadline, or even earlier if the participant brought it to your attention. Number 3, we've got to give that notice. We've got to do that within 45 days of starting correct deferrals, and then we've got to make any of those missed match contributions. So this is primarily noteworthy because this safe harbor was set to go away. It was going to sunset at the end of this year, and Secure 2.0 makes it permanent. It also clarifies for us that we can apply it to a terminated employee. There was some question about whether we could really do that. How do you really get correct deferrals going for a participant who no longer works for you, right? Well, Secure handles that and says, hey, you can do this if you've got a terminated employee, or also if the IRS finds the failure and you're working with the IRS, you can still fix it there. So we're going to get additional regulations. I think the final comment I would make here is the IRS has provided this safe harbor because it wants plan sponsors putting automatic enrollment into their plans. And as you might know, new plans that are established on or after the effective date of Secure 2.0 have to put automatic enrollment and automatic escalation into their plans beginning in 2025. I mean, that's a clear policy preference for us to have automatic enrollment in place. The final slide I want to show before we hop off today is an invitation to our Qualified Plan Fiduciary Summit. If you're interested in hearing a lot more about Secure 2.0 and how this will impact your plan, we have a keynote speaker, Fred Reich, probably the nation's most well-known ERISA attorney, will be talking about this during his keynote address. Sarah Semino will talk about this and how it relates to our communication with employees. And then as you can see, we've got a lot of additional information relating to communication with employees and participants. So we hope that you'll join us. You can scan the QR code or visit qpfs2023.com to register for that. So again, thanks so much for joining us. I think we're at the end of our 15-minute period here, but if you've got more questions, please don't hesitate to reach out. We'd be happy to help. Enjoy the rest of your day. Thanks so much.